Hi, this is Tricia Dunlap with Dunlap Law in Richmond, Virginia. We're a small business law firm where our mission is to help business leaders thrive. I'm here today to talk with you about a rule that is about to be passed by the Virginia Department of Labor and Industry related to COVID-19. This is really important for employers in Virginia to understand. The Virginia Department of Labor and Industry will be voting on this set of rules. It's actually 38 pages worth of rules. They'll be voting on this tomorrow, June 24th, and it's anticipated that it will pass. It will be the first time in the nation that we have binding rules on employers related to COVID-19 and workplace safety. At this point, even at the federal level, none of the federal agencies have issued any binding rules for which employers can be penalized if they don't comply. Virginia will be the first state that has rules that could lead to financial penalties and government enforcement actions against employers who do not comply with the rules. So let me give you a brief overview. These are complicated, and I'm going to have a brief on my website, dunlaplawplc.com, so that you can refer to that, because these rules are really too much to go into in depth in a short video. But I want to give you a high-level overview so you can begin thinking about it. First of all, the rules will go into effect on July 15th. So you'll have, about 19 days, I guess, to get ready for this. There are 4 risk classifications in the rules. There's very high, medium, and low. And by the way, these rules apply to every employer across the Commonwealth of Virginia, whether public or private, regardless of how many employees you have. So the first thing you've got to do as an employer, you need to do a risk assessment of all of the employment tasks in your business, so that you have evaluated both the physical environment and the administrative and procedural practices that you have in place, so that each of your employees, or if there are a group of them, can be classified according to risk level. So, for example, a very high risk level would be an employee who is perhaps performing certain dental procedures or intubating a either known COVID victim or a suspected COVID victim. That would be very high. Someone who falls in the high category might be a healthcare worker or a first responder who is dealing with a wide variety of sick people, some of whom might have COVID, but they're not necessarily known or suspected. And then at the medium level might be people who are working in physical settings where there's very close proximity to one another, like people working in meat processing plants where there's an assembly line and everybody is standing basically shoulder to shoulder, working near one another. And then the lowest risk are people who are going to be, further apart from one another. They are doing low risk tasks, and there perhaps are either physical barriers or just physical distance between themselves and other people. So number one, you need to classify all of your employees or your groups of employees and figure out which risk level they fall into. Then you need to develop policies and procedures for notifying your employees if a fellow employee has tested positive, or even if they haven't tested positive but they're suspected. You are going to have the duty to notify your employees if a fellow employee has gotten sick or you suspect they've gotten sick. There are also mandates related to when and how you can permit employees to work if they are suspected to be sick. If they have been sick, when and how you can let them return. There are mandates on how employees can be tested and if they refuse to get tested. It's extensive. Like I said, there's 38 pages of rules. I'm going to be working hard to get a brief together on my website, Dunlap Law PLC. You may want to refer to that once it's up and ready so that you can have your workplace ready. If you need help understanding these new rules and making sure that you comply, then please get in touch. There are really no exceptions necessarily for financial hardship, especially if other businesses within your same industry are implementing more rigorous safety protocols than you are. And there are financial penalties for failure to comply. So this is really important that you understand this. If this video has been helpful, please like, subscribe, share. We'll have more videos coming out about once a week. From Richmond, Virginia, I'm Trisha Dunlap. Thanks very much.